So before we get into the 14th Amendment, wanted to bring this to most people's attention. Not a lot of people are aware of this. The Bonus Army were 43,000 marchers, World War I veterans or families affiliated groups in the summer of 1932 to demand cash payment for redemption of their service certificates. They were the Bonus Expeditionary Force. The World War Adjusted Compensation Act of 1924 had awarded them bonuses in the form of certificates they could not redeem until 1945. Well, this was during the Great Depression, and they wanted their money now. The principal demand of the Bonus Army was immediate cash payment for their certificates. They were all broke. So who did they send in? General Douglas MacArthur, at the orders of President Herbert Hoover, ordered the Army to clear the marchers' campsite. Army Chief of Staff Douglas MacArthur commanded the infantry and cavalry, supported by 6 tanks. The Bonus Army marchers, where their wives and children were driven out and their shelters and belongings burned. A second, smaller Bonus Army tried in 1933, and Roosevelt disarmed them. And here you can see them with the American flag trying to confront the police as the military army is used against their own. Please do not forget that. All right, so 14th Amendment. So this is from a hero of ours, Mr. James Traficant. If you don't know who he is, you should look him up. But his U.S. citizens were classified as enemies of the state in 1933. 1933, volume 33, page 8, 1303. You think 3 is a big number with them. In 1933, the federal United States hypothecated. Hypothecate means to pledge a security without delivery or title of possession. That means you owe without having to give anything up. So in 1933, the federal government of the United States hypothecated all the present and future properties, assets, and labors of their, quote, subjects. Took all the present and future property, assets, and labor of their subjects. The 14th Amendment, U.S. citizen to the Federal Reserve System. 1913, The Creature from Jekyll Island, Griffin's book is a must-read about how the Federal Reserve was created. They sunk the Titanic because a couple of the rich, Astor and others, were on the ship to kill them so they wouldn't keep them from passing the Federal Reserve Act, which created the Federal Reserve, which is no more federal than Federal Express, but it prints money at interest for the U.S. government, making mint as our debt just keeps going higher. And we'll get into why the debt is important here. The 14th Amendment was put in place during a turbulent time in the Civil War. It was supposedly sold. It was to free the slaves. However, it made all Americans persons who were at the time New Yorkers, Virginians, and Pennsylvanians under the jurisdiction of a central federal government for the first time. Key time, 1933. So the Amendment Act, Amendment the 14th of 1868. All persons born or naturalized in the United States. Now remember, we've got a Constitution-free border I reported on the other day, 100 miles inland. So are they born in the United States? No. And subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, deprive them of personal life, liberty without due process of law, and deny a person with jurisdiction the equal protection of law. Hey, doesn't that sound great? Section 4, the validity of public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. Shall not be questioned. We cannot forget the 14th Amendment was not lawfully passed. This fact was exposed in Congressional Record of June 13th, 1967. The people are the enemy. Since March 9th, 1933, the United States has been in a state of declared emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and control the lives of American citizens. Senate Report 93-549. According to current laws as found in the USC Code 12, everything the President or the Secretary of Treasury has done since March 4th, 1933 is automatically approved. The actions, regulations, rules, licenses, orders, proclamations heretofore and hereafter taken, promulgated, made, or issued by the President of the United States or of the Secretary of the Treasury since 1933 are hereby approved and confirmed. Whatever they say is law. On March 9th, Congress approved in special session Proclamation 2038, became known as the Act of March 9th, 1933, that the Congress hereby declares that a serious national emergency exists and that it is imperatively necessary speedily to put into effect remedies of uniform national application. This is an example of the rule of necessity of rule of law where necessity knows no law. The rule is invoked to remove the authority of the Constitution. I argued that the Constitution was never for the people. We, the people, was the 39 rich white guys that signed it, that owned land. It wasn't the white guys that didn't own land. It wasn't women. It wasn't Native Americans. It wasn't the slaves. Nobody had the rights except the 39 rich white guys that own the land, because you cannot sign a contract, and the Constitution is a compact or contract. So again, on March 3rd, 1933, the Federal Reserve Bank, a private corporation, adopted a resolution stating that withdrawal of currency and gold from the banks had created a national emergency. Roosevelt was told to close down the banking system, told by a private corporation. He did so with the Proclamation 2039 under the excuse of alleged unwarranted hoarding of gold by Americans. Then the Proclamation 2040, he declared the existence of a national bank emergency, whereas all proclamations hereafter by the President conferred by Section 5, 1970 is amended or approved and confirmed. Once an emergency is declared, there is no common law and the Constitution is automatically abolished. There is no common law. We are no longer under law. Law has been abolished. We're under a system of war power since 1933. So again, U.S. citizens have no rights. Only state citizens have rights. They don't enter into contract with federal government claiming to be a U.S. citizen. This is the SESQV trust is not protected. Quote, citizenship of the United States does not entitle citizens to privileges and immunities of the citizens of the state, since privileges of one are not the same of the other. One may be a citizen of the state, yet not a citizen of the United States. See how they confuse everything, folks? And they put us on ships: citizenship, relationship, partnership, ownership. We're all at sea under admiralty law. So let's get into a little bit real quick about the difference between common law and civil law. Common law is admiralty law. It's when a judge decides who has been harmed and awards judgment to one plaintiff or one respondent on who has been injured. Civil law is crimes, harms, and criminal activities. In civil law countries, judges are often described as investigators. They take the lead in proceedings by bringing charges, establishing facts, witness examination, applying remedies found in legal codes, historical precedents. Their tasks include advising clients, points of law, preparing legal filings, and the importance of oral argument. This is why we have a hearing, because we have to speak our truth. One little sidebar here: when you testify, the word comes from testicles, because you used to have to grab your balls when you testified. That's where that comes from. And also get into Jordan Maxwell. He covers the whole legal shenanigans. The importance of oral argument in court presentations and active lawyering are diminished when compared to common law system. Common law, lawyers make presentations to the judge and sometimes jury. They're referred by the judge who's somewhat greater flexibility than a civil law system. In these cases, lawyers stand before the court, persuade others on points of law and fact, and maintain an active role. United States, common law countries. This is all admiralty law: United States, England, India, Canada. Civil law: China, Japan, Germany, France, and Spain. So civil is criminal activity. Common law is admiralty law, where we're out to sea and on our ships, our citizenships, relationships, ownerships, partnerships, all the ships. All right, so let's get over to where this all started. And this is USA versus the Republic. The USA, the Republic, is the house that no one lives in. And this is all created by design, folks. I'll put this in the show notes. It started with the divine right of kings. Human enslavement has taken all sorts of forms since the beginning of time. The most insidious form is when one individual, such as a king, claims that God gave him the right of enslavement. This is called the divine right of kings. At the root of this assumed right is the basic feudal slavery. The divine right of the King of England claimed it was the right to have absolute authority over every one of his subjects so they could not leave his political religious jurisdiction. That is, the king's subjects did not have the right to expatriate according to his assumed divine right over them. You are owned, folks. You are owned. That's what they're telling us. We are owned by the divine right and kings. Well, the Vatican got involved and took it to a whole nother level. Let's get into that. So another thing to understand about most Western laws, they originated in Rome. United States here, we're under Roman Latin law. Nobody can tell me what the word Latin even means, but we're under Roman Latin law. We have to have Latin dictionaries to define what the language means. It's all by intentional design and goes back thousands of years. Among many things that were important to our forefathers, the one that stood out was the establishment of a government free of any relationship of influence of the private Roman civil law operating and controlling public policy. It was the oppression of the Roman civil law as the king and parliament dictated that was at the foundation for seeking expatriation from England under the king's assumed divine right. The Roman civil law, also referred to as admiralty maritime law or the law of the sea, as well as private international law, was the result of a private church law operating for commercial purposes in the public sector, corporations. The amalgamation of church law and civil government was derived from three ingredients: Greece, Rome, and Christianity. The political theory derived from the first two of these ingredients was tempered to accommodate the third. Its originators and apologists were the first Christian emperor Constantine and the first historian of the Christian church, Eusebius of Caesarea. Through his writings, Eusebius had once and for all established a new way to interpret history, and his followers applied the same political philosophy for over 1,000 years. This is how long we've been controlled by the Roman Church, folks. And let's get into that a little bit more. Trust. We're all under the trust system. What is a trust? Well, they used to use it back in the Roman days when they were conquering everybody and ran out of gold. So they started to have to give the soldiers trust properties, and the properties had to be put into trust while they fought wars. Well, then they decided, well, let's use it a little different way in the history of trust. So way back in the first trust of the world, the Unum Sanctum is one of the most frightening documents of history and one of the most quoted as the primary document of the popes claiming their world power. It is an express trust deed. The last line reads, quote, "Furthermore, we declare, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to the Roman pontiff." End quote. It's not only the first trust deed in history, but also the largest trust ever conceived, as it claims the whole earth and everything on it conveyed into a trust. Their reasoning was that Jesus Christ, or the God, owns all lands, and since the Pope is closest to God as the vicar, he should be running the trust, taking care of all the mortals and all the lands. That's how they argued for it way back in 1302. So the Triple Crown of Baal, aka the Papal Tiara and Triregnum, and look at the crown here, folks, the Triple Crown. You see how you'll see the popes wearing this over and over. In 1302, Pope Boniface issued his infamous papal bull Unum Sanctum, the first express trust, claimed control over the whole earth, which made him king of the world. In celebration, he commissioned a gold-plated headdress the shape of a pine cone. The pine cone is an ancient symbol of fertility and one traditionally associated with Baal as well as the cult of Cybele. It represents the pineal gland in the center of our brains. Please look up what Baal means. The 13-foot-tall pine cone in Vatican Square represents this as well. This is about why popes would idolize a pine cone. All right, so the trust. The first SQV trust, the first crown of crown land. Pope Boniface VIII was the first leader in history to create the concept of a trust, but the first testamentary trust through a deed and will creating a deceased estate was created by Pope Nicholas V in 1455 through the papal bull Romanus Pontifex. This is one of 3 papal bulls to include the line with the incipit, quote, "for perpetual remembrance," end quote, which means in perpetuity, which means forever. This bull had the effect of conveying the right of the use of land as real property from the express trust Unum Sanctum to the control of the Pope and his successors in perpetuity. Hence, all land is claimed as, quote, crown land. This first crown is represented by the first SQV trust created when a child is born, your birth certificate, folks. That's why your foot lands on it. It deprives us all on beneficial entitlements and rights of land, right from birth. It was created in 1481 with the papal bull Aeterni Regis, meaning eternal crown, the second crown, and was created with, and notice the Aeterni Regis, attorney. Regis means crown. When you register for voting, regis means crown, stir means to enroll. You're enrolling in the crown. All right, so the second crown created in 1481 by Sixtus IV, being only the second of the three papal bulls as deeds of the testamentary trust. The papal bull created the crown of Aragon, later known as the crown of Spain, and is the highest sovereign and highest steward of all Roman slaves, subject to the rule of Roman pontiff. Spain lost the crown in 1604 when it was granted to King James I of England by Pope Paul V after the successful passage of the Union Crowns, or the Commonwealth. Notice the British is called the British Commonwealth. In 1605, after the false flag operation of the Gunpowder Plot, you can see V for Vendetta. The Jesuit movie is about that as well. The crown was finally lost in England in 1975 and returned to King Carlos. The second crown is represented by the Second Sesquivi Trust and is created when a child is born and by the sale of the birth certificate as a bond to the private central bank of a nation, depriving us of ownership of our flesh and condemning us to perpetual servitude as a Roman person or slave. Read that again. The second trust is when we're born, depriving us of ownership of our flesh and our souls, and condemning us into perpetual servitude as a Roman person or slave. The third crown, or ecclesiastical see, remember the Vatican's called the Holy See, Admiralty Law. In 1537, by Paul III, through the papal bull Convocation, also meant to open the Council of Trent, it is the third and final testamentary deed and will of testamentary trust, setting up for claiming all lost souls lost to sea. The Venetians assisted in this as well as creating it. The crown was lost in 1816 due to deliberate bankruptcy of England and granted to the Temple Bar, this is where bar attorneys come from, which are known as the Crown Bar, or simply the Crown. The bar associations have since been responsible for administering the reaping of the souls of the lost and damned, including the registration, regis means crown, and collection of baptismal certificates representing the souls collected by the Vatican and stored in its vaults. The third crown is represented by the third sesquivi, created when a child is baptized. Its parents' grant of the baptismal certificate is title to the soul to the church of the registrar. Thus, without legal title over one's soul, we will be denied legal standing and will be treated as things, cargo without souls, upon which the bar, the British accredited registry, is now legally able to enforce maritime law. And finally, the Sesquivi Trust is a fictional concept. It is a temporary testimonial trust, first created during the reign of Henry VIII of England through the Sesquivi Act of 1540 and updated by Charles II through the Sesquivi Act of 1666, where an estate may be effected for the benefit of a person presumed lost or abandoned at sea and therefore assumed dead after 7 years. So after 7 years of your birth, if you don't claim your right of being your own soul, it's lost to the Pope and to the Vatican and to their bullshit trusts. All right, so let's move forward to the 14th Amendment. Now, the key important dates, remember February 23rd, 1871 is when the federal government corporation, capital letters, USA was created that put us all on the ships. But this took away all our rights, to take away all our souls. The 14th Amendment of the United States is Roman civil law in 1868. A momentum to bring the 14th Amendment was one of the first. Was the Constitution made it plain every citizen had the right to contract away his personal absolute rights. We're all under contract, folks. It's contract law. Your birth certificate, your driver's license, your social security number, your bank statements, they're all in capital letters. This means you're part of Roman Latin law. You're under the federal jurisdiction of the corporation. You're a dead entity when you sign and contract your life away. So the Bill of Rights, they wanted to be on private contract. However, the opposite vein, they could walk back into constitutional government. This was called the right of expatriation. The 14th Amendment is a private unilateral contract being used in the public sector to dictate public policy. Everyone born since 1868 has by accident at birth become subject to the 14th Amendment. Subject to, in quotes, is accomplished through the constructive trust created under the Roman civil law offer and acceptance principles. You must have an offer and an acceptance. That's contract law, except for the rehypothecation, which means nothing has to be given in gratitude for your services or actions, possessions. So acceptance principles, ramifications, including being citizens primarily of the United States government and not the state in which you live. The 14th Amendment does not say that all persons are subject to, it says and subject to, which is the first clue to revealing that each citizen does not have a choice as to whether or not they want to be subject to. Subjects. Isn't that what the Queen says? You're my subjects. In 1851, an act was passed called the Limited Liability Act. Now, I asked my attorney one time when he was putting under me a corporation in their Limited Liability Act, I said, well, if I'm limited liability, it's my property and things happen to it, who takes up the liability? He said, in my 20 years of practice, nobody's ever asked me that question. This act provided protection for owners of ships whose cargo and ship was lost at sea. The ship owner investors were required to purchase maritime insurance. They saw limited liability as a way to take more risk to advance their profits and making the corporation king. By pushing the problem of slavery, the real issue of economic control by private corporate structure could be advanced unnoticed, the first phase of the bait and switch tactic. So with the culmination of the Civil War and the Northern Industrial Prime, the slaves are now free of being chattel. At this point, corporate Big Brother made a calculated move. Since the freed slaves, as well as the rest of the citizenry, were ignorant of how their freedoms were maintained, it was a perfect time to activate the second part of the bait and switch maneuver. That was set a law into motion with a congressional fanfare to assure the freed slaves they had civil rights for everyone. Thus came about the Civil Rights Act of 1866, there's that number again, which was private or non-positive law. The basic problem of the act was that it had no jurisdiction over the slave at all, but the lawmakers sure made it look that way. It was private law that not only affected those who were in contractual relations with the private corporate structure of the United States government. None of the freed slaves had any type of license with the United States government, so it did nothing other than play on their ignorance and make them look like they did something. For those it did affect, these holding licenses are under contract with the United States government. It did two primary things. First, it took away absolute property rights. So you don't own your property. It's a certificate of title, folks. You don't own the property. You don't own anything above it. This is all part of their game. The Queen owns most of all lands. Second, it replaced them with the personal property rights, regardless of race. That was the Civil Rights Act of 1866, moved anyone in its jurisdiction away from real property law and established them in personal property law, outside the protection of general common law and the Constitution with its separation of powers. Very cute how they did that, right? It meant the death knell of the doctrine of states' rights, the ultimate nationalization of all civil rights, and the consequent abolition of state control over private rights and duties of the individual. It meant the passing over of the police power of the state into the police power of the national government, thereby giving Congress undefined and unlimited powers, whereby it would be enabled to enter fields of legislation from which hitherto it had been barred. The states of this union were never sovereign. Neither is the federal government sovereign. Sovereignty is now and has always been inherent in people. 1868 passed the 14th Amendment. First, it made each individual primarily a federal citizen of the municipal corporation of the District of Columbia. Second, it combined the Senate and House in their function, so they're now operating for the benefit of private commercial law. Until the 14th Amendment, the House functioned for private commercial benefit and the state functioned for non-commercial public municipal law benefit, the benefit of the individual under Republican law. Note that the word democracy or democratic does not appear in the Constitution, only the republic. Third, it made each person responsible for public debt. See, the more they run up the debt, the more we owe to the banksters. By making them beneficiaries of the public trust, the 14th Amendment was established. So it was not until the purported passage of the 14th Amendment that the continual push of private law into the public sector won out. At that point, private conscience private conscience law of the Roman Church became the national conscience by the way of the 14th Amendment Trust of the District of Columbia. Interestingly, Congress knew that it was making an amendment that was based on private, non-positive law and was thereby conditional. The people had to have a choice whether they wanted to participate or not. Otherwise, it would have been totally and completely unconstitutional. One day before the 14th Amendment was passed, Congress passed 15 Stat 24950. This statute provided for a person to remove him or herself from the jurisdiction of the 14th Amendment public trust if they so desired. You had 1 day to remove yourself from being owned and an enemy of the state. All right, so yet there is a very important facet of the power to contract under private law. That is, if contract private laws come into dispute in the courts, the contract will be ruled on outside of the Constitution. Contracts or private agreements will always overrule the Constitution and Bill of Rights. Specific private agreements called contracts governing individual circumstances between two or more persons will always overrule broad or general clauses of the Constitution. When the 14th Amendment came along, the United States district courts could have jurisdiction in private matters of individuals involved in the trust because the trust and its members now came under admiralty maritime law outside the Constitution, as did all international trade. At that point, federal courts were given in rem jurisdiction over the people. The res was the people. Res means residence. Res means property or thing. Resident means identifying the property or thing. So your resident is identifying a property or thing, not a human. The in persona jurisdiction did not apply to the average citizen because the government had no direct contact with the people who lived in the states until after 1933. When the fixed gold standard was removed, the people lost their law. Before 1933, the federal courts could not assume jurisdiction over a person. So when we lost the gold standard, folks, we lost our rights. What are they going to do now? They're maybe getting rid of the gold and turning it into cryptocurrency. Before 1933, the federal government could assume jurisdiction over a person. There had to be some bilateral arrangement under contract that would be given the court jurisdiction over the people in persona. Every judge can render decisions based on his own prejudice, not on constitutional law or republic, courtesy of the 14th Amendment. And here you can see it's backed up over and over again. Also look up corporate personhood. We're back again in the 1860s, 1870s. They created the corporate person, which has the same legal rights as a human. All right, so I'm going to wrap it up here. Thank you all for staying with me. I hope it hasn't been too much for you to cover. This is another very important website, USA versus US.info. Describes the descriptions between the original and the corporation that was created in February 21st, 1871. I say February 23rd, with the Organic Act creating the Corporation of the United States, capital letters. But this is a very good side-by-side between the small capital United States of America and the large capital United States Corporation of America. One is a de jure form of government, legitimate, lawful right by law, and the other is a de facto government, state of affairs, legal, legitimate, equity, not by law. It's not constitutional. So they got us on our ships. They got us off the reservation. They got us off as being human beings. They've claimed our souls. They've told us we're enemies of the state. They told us we no longer have a life, liberty, or the pursuit of happiness as we were sold. That we live in a democracy where the priests rule, or mob rules as you look at it here. But it's all by lies and deceits, and it's been going on for thousands of years. And the good news is it's over. We're waking up. We're learning about our enslavement. We're learning how we have no rights. They can spray us like bugs with geoengineering. They can arrest us and have indefinite detention. They can set up 100-mile Constitution-free zones, and nobody says a damn thing about it. The United States flag is a military flag, folks. The flag in courts has a gold fringe on it as well. That's why you know you're under admiralty law. So I'll put this in the show notes, but it's a very good side-by-side explanation between lawful money and legal money. It's all by words. It's all using our swords as words to slice us up and dice us up, and basically to reap harvest on all our souls so that the evil doers can really, truly control all and have dominion over this world for their own sake and for their own doing. We are sovereign beings. We're living souls coming out of our mother's womb into the land of several states. Sovereign, free man, free inhabitant, and freeborn, unless that right is giving up knowingly. The key is knowingly. They've committed fraud by deception and signing contracts we're not aware of. To be sovereign is a chief ruler with supreme power, one possessing sovereignty. I am a sovereign being. Sovereignty resides in the body of the people. It's the people. It's not a fictitious character. It is a person with living soul in flesh and blood, includes women and child, as opposed to a legal name which they give us as part of the straw man, which we'll get into in the next video. Anyway, maintaining your sovereignty is really critical now, understanding that you've been put under legalese, you're a servant under debt, but you have unalienable rights. We need to exercise those rights, and I'm saying again and again, be the author of your own authority and get back to a system of look, touch, and feel for those in your area that you can look, touch, and feel. Those are the only laws that can be mandated. The look, touch, and feel, those are the only ways you can come to agreements and set up your own types of jurisdictions, not in some one person that rules 315 million people you see on TV, and then once every 4 years you go push a button and hope that the guy you like or the guy you don't like doesn't get into office to rule you. That's our world now. So happy 4th of July, everybody. It means nothing. It's all about our enslavement. If you think of the song about the 4th of July, it's about bombing people. Bombs, war, fireworks. We must end it. We must end with love, peace, and being the author of your own authority. All right, plain truth out. Love one another. Know your laws. Know your rights. They can't take it away from you. It's in you. Sui juris, one's own right, one who has all the rights to which a free man is entitled, one who is not under the power of another, as a slave and minor and the like. Got it? All right. Plain truth out. Catch you next video. Peace.